Hello, Leanne.
Hi, Steve. How are you today?
I'm good. And today we are discussing how to seek and improve court orders to protect victims or potential victims of family violence. So I'm going to take a few minutes just to go backwards and discuss first principles. In Canada and Ontario, people are expected to be able to live independently and live safely. Those people who are in relationships have added protections found under provincial legislation. Specifically, people with no children could seek a restraining order under the Family Law Act, provided that they are in a spousal relationship, which is either people who are married or people who have a child in common or people that may have lived together for 3 years or more. Under the Children's Law Reform Act, people that have a child in common can seek a restraining order. And in both cases, whether under the Family Law Act or the Children's Law Reform Act, the application and therefore the motion for a restraining order would be brought before a judge on written material, sworn evidence, and then argued in front of the judge, where a judge would ask questions and decide whether there should be such an order made in family court. Now, a lot of those orders are made on what's called an ex parte basis, meaning the victim who may have fled a violent relationship appears in court, uses duty counsel. I remember doing this many, many times when I was a younger lawyer, and I represented somebody that just showed up in court and needed a restraining order. And then I would whip up in written form affidavit material, and I would go in front of a judge literally within minutes, if not hours, and I would ask for and many times receive a restraining order. And when they are granted, they're often granted for 7 days to about 21 days. And then they have to come back to court after the so-called perpetrator of violence gets served and has an opportunity to come to court with a lawyer or without a lawyer and deliver their version of what happened, at which point the judge will either extend the restraining order or end it. Now, so those are methods in which people have historically obtained a restraining order. And I understand that the government had sent out some sort of request for more information to deal with that. What do you know about that, Leanne?
I know that the Law Commission of Ontario right now is seeking input from the community. This includes the legal community, but also the community at large, so anyone in the community, for their input on how they can improve protection orders for family law or for family violence. And this is including not just the restraining orders that you just described, Steve, but also things like peace bonds, which are found more in the criminal courts, and with bail conditions and things like that. So it's affecting both criminal law and family law, and essentially victims of family violence.
That's very interesting. The subject of family violence, which, by the way, goes under many different words: domestic violence, coercive control, spousal violence,
intimate partner violence,
IPV, intimate partner violence. It's hard to keep up, actually, and I always wonder what's the difference between one and the other. And from where I sit, when somebody treats another person with disrespect, either with force, with words, or with other form of actions, in all forms, it's abuse, and it's not tolerable and not acceptable in our society. But with that said, I get calls probably 1 or 2 a month from people that are terrified of their spouse. And in some cases, they're still living with them. And they're calling me either outside of the house in the car, or they're calling me when the other person has left the house, or they're calling me when they themselves are outside of the house, and they are shaking and fearful. And they want to know, what are my remedies? And I tell them what I just told all of our viewers today. But I also say to them, that it's tremendous bravery to recognize that this is unacceptable and that you need to seek safety and you need to seek legal protection. And there are many avenues for people to do that. Nobody should ever remain in a situation where they or their children, or quite frankly, their property, may be at risk of injury. With that said, a lot of people do remain in those relationships, and without judging their actions and without judging their decisions, they do so because there are other considerations. Sometimes they don't want to leave because they don't want to disrupt the children's lives. Sometimes they don't want to leave because they can't afford to. Sometimes they don't want to leave because they're afraid of their family and friends' reaction. And in some cases, they don't want to leave because they're afraid that if they do leave, worse things will happen to them. Mm-hmm. And for those that might be watching this video one day, I certainly hope you're not a victim or a soon-to-be victim of violence. But if you are, there is absolutely no question in my mind that you must immediately remove yourself from the ambit of danger and find safe refuge. That could mean going directly to a police station, going directly to a hospital, a community center, a walk-in medical center. But one way or the other, it's critical that you not leave yourself there, because every day in Toronto, in Ontario, and in Canada, people who are in spousal relationships are abused and in some cases murdered. And there's a lot in between those two. But one thing that I say to these people that call me is, if the person's behavior falls on criminal behavior under the criminal code, which I'm going to pass this on to you in a moment, Leanne, because that was your forte. If the person's behavior, whether it's through an action like a battery or a threat of battery or a threat of murder or even a threat to a child or to your property or to your dog, all of that is actionable by going to the police and asking for the protection of the police. At minimum, the police will make notes of it. They will visit the perpetrator, and maybe it's not as bad as you thought it was. The police will at least examine the situation, and I have found in some cases where it's really just a verbal argument, when the police show up, it causes people who are sort of ratcheting things up to start behaving more appropriately. And in some cases, the police might arrest the person and remove them from a home, and then, of course, release them on bail under terms that do not allow them to come back or to come back near you. But really what I'm saying is, in some situations, the right route is the criminal route, because the alternative route is dangerous or expensive.
Yes, because the criminal route, the police will protect you, and the charge will be laid, and the Crown will prosecute, and you don't have to have a lawyer. You don't have to do anything for that. The perpetrator may need to get a lawyer, but as the victim or the complainant, you will not have to get a lawyer. And as some of our listeners may know, for many years, I was an assistant Crown attorney, and I was the co-lead of the domestic violence team in the Toronto West Crown Attorney's Office. So it's an area where I received a lot of training on cases of domestic violence or intimate partner abuse. And one of the things that we were continually taught is that the research shows that one of the absolutely most dangerous times for a victim of domestic violence is during the initial separation phase. So for that reason, Steve and I are dealing with a lot of people, if they've been in an abusive relationship, where they are actually at the most dangerous time in their relationship. Sadly, a lot of the murders we've seen, or the murder suicides and those types of things that happen after a victim of domestic violence has left the perpetrator or is taking steps to leave. And so for that reason, we very much understand the fear that a victim has of leaving, knowing that that is such a dangerous time. And so, if there are threats or if you are afraid, the best thing you can do is contact the police, because they can lay a charge. They can, and if the perpetrator is especially dangerous, they can be, put in jail. They may be denied bail if there's a history that supports that. But certainly, if they are released, they'll be put on strict terms not to have contact with you. And should they try, that's breaching their bail, that's another charge, and you can contact the police and they will lay another charge, and the perpetrator is going to be even in more difficulty and more trouble with the courts. And for those out there who are struggling to leave, I think, a lot of us who are parents, we always, think about our children and how are things affecting their children. And it's important to understand that there's a lot of research out there that shows that girls who grow up in homes where their father is abusing their mother, they carry on that pattern and seek out relationships and stay in relationships as they get older, where they themselves are being abused. They model what their mother was doing. And the research shows that the sons who grow up in that atmosphere, end up copying their dad's behavior and modeling their dad's behavior, and they go on to be abusers themselves. So that's just another reason why, not only for you saving yourself and protecting yourself, but also for your children, it's so important to leave. Because even if you think they're in their bedroom and the door is closed and you think they don't know what's going on, children are very smart and they do know. And family violence, even if it's not on the children, it's between the parents, it has a tremendous impact on them. And, as we as parents want to protect our children, we want them to have the best chance at a happy life. So it's important to think about that when you're making the decision to leave.
Excellent advice. I'm going to create a fact scenario, and it's going to be about Jack and Diane. And I'm going to ask you, what would Diane do down the criminal avenue?
Okay.
But I'm going to answer the same question down the family law avenue, so that those watching this video one day will know what are the various options available to them. So the scenario is as follows. Jack and Diane have been together for 8 years. They've got 2 children who are 4 and 6. They've always had a very good relationship. In fact, very passionate relationship. In fact, Jack and Diane, one of the things that has kept them together all these years is a very healthy sexual relationship, filled with passion, filled with emotion, and very physical relationship. Well, in the last few years, they've had some financial problems. Some of Jack's friends have, let's just say, not been very savory people. Diane expressed her wish that Jack wasn't connecting with them, going out with them. And this, between the financial problems and the fact that they've got kids, things have gotten a little less romantic. And sometimes Jack comes home after having too many, and he hasn't been, let's just say, very pleasant to be around. And a couple of times, Jack and Diane have fought. Kids have woken up. Kids come out. And Jack just walks out, storms out. But the client called last week, Diane. She's not a client, but she might be a client, to say that in the last few weeks, things have gotten a little heated. Rather than just slamming the door on his way out, he threw the remote at her and hit her in the head, and she got a cut above her eyebrow. And then last night, she was standing at the door when he came in, and they started fighting, and he pushed her and left, and she fell down. And she's described that things have just gotten more difficult, and she's actually afraid to leave the kids in his care. She would have liked to go out, but she's afraid he's going to drink and then potentially be a risk to the kids. And she's also afraid to say to him that she wants to leave him. In fact, she's not even sure she wants to leave him, but she certainly knows she and the kids are in danger. And she calls me and she says, what should I do? So I'm going to give her the answer as a family law lawyer. And I'd like you to give her the answer in terms of what she could do if she were to go the criminal route.
Okay.
If she were to go into the family route, she would retain a lawyer either with her own money or on legal aid. Or thirdly, she would walk into a courthouse tomorrow morning, not at night, but in the morning, and she would ask either the lawyer who she pays or legal aid. She would have to apply for legal aid. It could take anywhere from 2 to 6 weeks to get a legal aid certificate. And then she would have to walk into a lawyer's office who would accept the legal aid certificate and then begin working on her case, which could take another couple of months. Some of that could be abbreviated if she paid a lawyer. If she paid a lawyer to do all of that, it would likely cost her anywhere from $4,000 to $8,000, and it could be done in a couple of days. The third option is she could walk into any provincial family courthouse in the province and ask duty counsel to help her prepare the court documents and go in front of a judge that day. Diane says she doesn't know how to do any of that. She wants to hire a lawyer. So then she goes route A or B, i.e. private lawyer, $4,000 to $8,000, or legal aid, 2 to 3 months. But she has the option of going into any provincial courthouse tomorrow morning, asking duty counsel to help her prepare the documents and go in front of a judge for what's called an ex parte motion, where a judge is going to only hear one side. And God help her, she better be completely honest with what she puts into that affidavit, because if she exaggerates the situation or misleads the court, not only will that order later be canceled, but there could be some very negative consequences to her regarding money and the kids. So at the end of the day, she's got those 3 options. And if she gets the court order, whether through Avenue 1, 2, or 3, that order is generally a temporary restraining order that says he is not allowed to come near her or back to the home. And in some cases, it'll even say that the children are to remain in her care and control. Those orders are made for anywhere from 1 to 2 weeks. And at that point, the order that she got in court tomorrow morning would then be immediately served on Jack. And he would be told, you are not allowed to come back home. You are not allowed to come near her. In fact, it might even say you're not even allowed to communicate with her by phone or by text or by email. And then the lawyer that represents her, and of course, she does not have a lawyer under option 3. It's option 1 or 2 that she has a lawyer, would say to Jack, if you have anything to say to her, if you have any questions, direct them to me. You're not allowed to communicate with her. And if you do, you're violating the order and you will be picked up and arrested, because the breach of a restraining order under family law is a criminal offense. And so that would be the avenue in family court. Let's hear about what the avenue would be if she went the criminal route.
So on the criminal side of things, Diane could contact the police, and she would tell them what had happened. Essentially, the 2 main incidents. You give a bit of the history leading up to it, but the incident involving the remote control being thrown at her and hitting her and causing an injury, and also the push the next day. Both of those are criminal offenses. So upon hearing that information, it's very likely that the police would proceed to lay charges. On those facts, I see a couple of charges. So the first one with the remote control would be assault with a weapon. It would be helpful if Diane had taken a photo when it happened, like if there was bleeding, if she'd taken a photo on her phone of the bleeding. But certainly even, by the time she's reporting it the next day, if there's a cut or whatnot, the police will want to take a photo of that. And then the push is an assault. So there's two possible charges that could be laid there. And if the police proceed with the charges, and they would, if Diane conveys that information to them, and Diane comes across credibly, they have reasonable and probable grounds to lay those charges. So they would proceed to do that, whether Diane really wanted them to or not. They have also a duty to proceed ahead. It's not necessarily at that point Diane's choice whether charges are laid. And so there would be a warrant for Jack's arrest. And when he's arrested, he would then, there's two things that could happen. So one is if he has no prior criminal record, the police would probably release him at the police station after taking photos and fingerprints and that sort of thing. They would release him on what's called an undertaking, and the undertaking would have conditions which would include that he's not to have any contact directly or indirectly with Diane, that he's not to attend within a certain distance of anywhere she's known to be. So that would include the home, that would include where she works, if she works outside the home, or if she goes to school or places like children's school, the children's daycare. He would not be allowed to go to any of those places. So it would be a way of getting him out of the matrimonial home, which is important if Diane's afraid. And he would have to go and stay elsewhere and find somewhere else to stay. Alternatively, if the police think that he is more dangerous, like if he has perhaps a prior criminal record for domestic violence, or even a prior criminal record involving just violence. It could even be on men, assaults on men, a bar fight, things like that.
Or on an animal.
They may choose to hold him for a bail hearing, which is called a show cause. And depending on whether in that situation, either the Crown has to show cause why he should be detained, or he would have to show cause why he should be released, depending on some legal issues. But at any rate, there would be a bail hearing with the Justice of the Peace, and the Justice of the Peace would decide if he should be released and on what terms. And usually when there's a bail hearing, if somebody is released, they have to be released to someone we call a surety. So it could be a parent, it could be a friend, it could be an employer, but somebody respectable who doesn't have a criminal record would have to come down and essentially bail Jack out and act as a surety, which means they're agreeing to supervise Jack while he's on release, which means they have to make sure that Jack complies with all of the conditions on his bail, which will also, again, just like the undertaking, it will include terms that he not have contact with Diane, that he stay away from them wherever she is living, working, anywhere she's known to be. On both types of release as well, there would likely be a condition that contact with the children is to be arranged either through a mutually agreeable third party or pursuant to a family court order. So he may not be allowed to have contact with the children until there's a family court order in place. And the criminal charge could go on. So he could be on these conditions for many, many months. If he chooses to resolve it and plead guilty, or negotiate something called a peace bond, then he'll likely still have those conditions for a period of time. But if Diane wants to reconcile or wants to be able to see him or have contact, she would have some say in that. She may be able to provide her written revocable consent to have that contact. If the matter is going to trial, a trial may not be for a year or more. So he would be on those conditions for that period of time. And then Diane would have to testify at the trial, and there would be a finding of guilt or not guilty. And if it's guilt, there would be a sentence, which again would likely include terms with respect to his contact with Diane. But Diane doesn't have to pay anything for any of that. It's the police and the Crown's office and the courts that would do all of that. And on the facts as you described them, Steve, there certainly are grounds for Diane to go that route.
So in a situation that I've just described, where I've provided some evidence or some suggestion that there has been physical contact, either by way of object or by way of body to body, I think this is a situation that could easily fall into both the family law and the criminal law sphere. But sadly, we have a lot of cases where it's mostly verbal, emotional, and psychological abuse, which generally is currently not criminal in nature, but the person still has the freedom and the remedy to seek relief in family court. But it would be obviously up to the Crown to ascertain whether the verbal, emotional, and psychological abuse meets any threshold test that might result in the criminal law giving this victim protection. What would happen, by the way, if you removed the physical contact and it was all verbal?
There would have to be a threat to cause harm to either Diane or her property. That would be a criminal offense. Or there is a broader offense called criminal harassment, which usually involves like more than one instance. And on the facts you described, there's a couple of things that happen, but that can include, verbal harassment and any behavior, stalking, controlling behavior, anything that causes Diane to fear for her safety.
Right. Well, these are very difficult subjects. There's not one answer that fits all victims. And in many cases, the act of the victim to out the problem is the beginning of the recovery period for the perpetrator. And like you said, Leanne, it's the beginning of the lessons to the children that this is not appropriate behavior. A woman should never be treated this way, and a man should never be treated this way. And a boy growing up to be a partner should not be treating his partner, new partner, girlfriend, wife that way, and so forth. And so I hope for those people that have joined us today or will be watching this replay that this information has been helpful. I hope nobody that watches this requires this information, but should you or a friend, family member, or a neighbor do require the protection of the law, please take action immediately to seek that protection for yourself, for your children, or for your family member or friend. So thank you for having us today.
Thanks, everyone. We'll see you next time.